Hello and welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the EDRM CEO and Chief Legal Technologist. Today's webinar is a collaboration with our trusted partner, Proteus Discovery Group. Today's discussion is how to talk to your litigators about eDiscovery with our faculty experts, Ray Biederman and Francesca Morrency. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar, and this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstead, EDRM's Chief Strategy Officer, is here with us. Can you please share what resources are available today, Kaylee?
As long as you can hear me, Mary Mack.
I definitely can, Kaylee Wallstead. You go.
Fantastic. We're loving On 24 with so many more ways for you, our audience, to engage, and we hope you're enjoying it. Check out your console to the right of your screen, and you'll see a question mark icon. And if you click on it, this is where you can type in your questions for today's faculty, and we highly encourage you to do so. You'll see the paperclip icon. Click that for related content, and you'll see today's resources carefully curated just for you. There's an On24 engagement tools descriptor for you to download to help you better engage with the platform. Additionally, there's a link to learn more about EDRM's trusted partner, Proteus Discovery Group. Be sure to check out their incredible services. Also a link to check out their latest article on navigating the complexities of social media discovery, which don't we all know there's a ton. There's also a link to schedule a meeting with the experts at Proteus to learn more about their excellent suite of services and what they do. And up next on EDRM's webinar channel next week, July 23rd, Mastering the Data Frontier, a galactic guide to streamlining your eDiscovery. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, you'll see the smiley face emoji. And if you click on it, there are many more reactions that you can click on during the webinar. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform, so give it a go now. You'll also see the Twitter bird, that's for social media. You can follow EDRM and Proteus Discovery Group on LinkedIn. And back to you, Mary, and make sure if you're not speaking to mute yourself. I do hear some background noise.
All right, well, I am unmuted now, and I'll say that all opinions expressed here are our faculty's own, not those of their firms or clients, and no legal advice is being provided. And our faculty is absolutely stellar today. Ray Biederman is the CEO of Proteus Discovery Group, and he's worked in every phase of eDiscovery for more than 2 decades. He's a super lawyer in the area of eDiscovery and has been cited in multiple court opinions as an expert witness. And he's an adjunct faculty for eDiscovery at IUPUI School of Informatics and Computing. He consults on information governance policies and procedures related to cybersecurity and its intersection with government regulation and industry-specific best practices. Outside of his eDiscovery experience, Ray's an active litigator representing clients in products liability work, business valuation disputes, and contracts disputes. He's also a founding partner in Mattingly, Burke, Cohen, and Biederman. He was previously an associate at Barnes & Thornburg. And with him is Francesca Morrency. She's a partner at Orrick, Harrington, and Sutcliffe. She's a member of Orrick's complex litigation and dispute resolution team with an extensive experience litigating challenging high-stakes cases on behalf of her clients, including some of the most high-profile and impactful wins for the NCAA. In addition to her trial prowess, she also has conducted internal investigations and has been called upon to assist with regulatory and administrative challenges that her clients face in the day-to-day. Francesca has guided the preparation of significant litigation and arbitration matters from the drafting stage through discovery, depositions, expert and lay witnesses, and through motions and trial. Having served on a secondment to a Fortune 5 client, she understands well the importance of effective and proactive case management. And prior to working in private practice, Francesca served as a judicial clerk to the Honorable Judge Ivan D. Davis, a United States Magistrate Judge in the Eastern District of Virginia. And in that role, she handled primarily civil discovery matters. And without further ado, Ray, take it away and tell us how to talk to you litigators.
Excellent. Well, thank you very much, EDRM, for having us today. And thank you for that excellent introduction. I'm going to have to keep a separate recording of that just to listen to it from time to time, because that was just so wonderful. So thank you. Just to set the tone here today, please feel free to jump in with questions as we go. Francesca and I, we're going to have a back and forth banter about some of these topics in the EDRM, what's important to litigators and what's important to technologists, and where those things sometimes go awry, so where that communication process breaks down. So we'll talk about why this is important first, then we'll move into highlighted steps in the process. And as we go through that, we're going to highlight some key takeaways. And then we're going to wrap up with those key takeaways and then have some Q&A related to it. So feel free to jump in during, or you can hold your questions till the end, totally up to you. We're very flexible with this. We want this to be a conversation and not necessarily a presentation. Before I jump to the next slide, Francesca, anything to add to that?
No, I think you covered it well, and I'm really excited to get into some banter with you.
Excellent. There we go. All right, so let's talk about the communication breakdown. So basically, when we are involved in a piece of litigation or an investigation of some sort, there are certain things that us as eDiscovery practitioners or technologists care about and think are tantamount to a given investigation or help us get our job done. But a lot of times, those things aren't necessarily what's the most important aspect of the litigation or the most important aspect of the investigation. And so just setting the stage for this conversation and how this conflict comes up, let's take a look at why we should care about this. So attorneys have certain ethical responsibilities related to the practice of law. One of them has to do with Rule 1.1, which is the duty of competence. And so there is a footnote to Model Rule 1.1 that talks about the importance of litigators understanding the technology or the communication technologies that occur. There's even, I believe that Colorado states this very, very clearly, that attorneys need to stay abreast of emerging communication technologies. And so this can be anything from people having Twitter fights to people, or X fights, excuse me, or people discussing, important strategic plans over things like Signal. So that all sorts of these technologies are emerging every day, and it's an attorney's duty to understand those technologies. But there's a great case from the Northern District of Illinois that this opinion, it was a 100-page opinion where we talked about some issues that occurred during the discovery process. And one key takeaway from that was that the court doesn't demand the level of expertise for attorneys, but it expects that there's a reasonable understanding of ESI and the law relating to identifying, preserving, collecting, and producing an ESI, in addition to the good faith compliance by parties and counsel. So that is a basis that litigators come to these decisions that they're making with regard to what's important at a given time in a case, or what may not be important at a given time in a case. In addition to that, there's more guidance in the federal rules of civil procedure. Each state has their own interpretations and different wording of some of this, but there's this duty to supplement and correct disclosures in a timely manner when someone learns about an incorrect statement or an incomplete statement in some of these disclosures. Now, this can happen in a number of ways. It doesn't necessarily have to be you send an amended disclosure, although you can do that. This can happen in the course of a deposition or in the course of discovery responses. So it's not necessarily a hard and fast rule that if X happens, you must do Y, but rather it's something that we need to stay abreast of. And that's where us as technologists can come in and add a lot of value. Is we sit in, we understand what's going on at any given moment with regard to what data has been collected, what data has not been collected, and the reason for those decisions that were made. And then we can supplement and add to the intelligence of our litigators that are working on this, so they have a good understanding, can have some decision making around why we're choosing the paths that we're choosing. So I spoke a lot there, Francesca. Please jump in and correct me where I went wrong.
I think the importance there is litigators are going to be in a position where they're going to have to make representations to the court. And so striking a balance of, understanding enough that you are making a good faith representation, but not becoming your own expert to the point where at that point, why would you need a vendor? If we're going to bill hundreds and hundreds of hours becoming ESI experts, it's sort of, you lose the point of having someone like Ray's team there to make sure that it's being done in a very detailed and thorough manner. So I think it's all about finding a balance and figuring out how can we, as litigators, comply with our duties before the court while also having reasonable bills for our clients, as well as getting things done in a timely manner.
Yeah, that's absolutely, that's a great point. And Francesca, just to be clear, you didn't go to law school to work with computer technology, right?
I didn't. Honestly, I didn't even know how deep you could go into that world until I met you and Proteus, Ray. I will be honest.
Well, that's great. Yeah. So and that's true for the vast majority of litigators. They didn't go to school to have to understand data systems and complex data structures. They went to school to practice law and to work on the merits of cases and to make a difference there. And so our job is to take away that noise, to allow people like Francesca to get in and argue the merits of the case. All right. So looks like we had one question jump in there. Are you saying that your work at a minimum must be defensible? Absolutely. So one of the things that we preach is defensible and repeatable. So defensible can happen in one context, but having the added benefit of it being repeatable further bolsters your process. So if you have a process that you can do multiple times in a row, that's like the gold standard, right? So we want to, if we're working with clients and getting in deep with them and have multiple matters, we want to be able to know how to set up a process that we can repeat every time. But in addition to that, we need to know when to be flexible enough or adaptable enough to change that process. So we can't be rigid in it, but having a process that's repeatable does help with defensibility. Great question, Barry. Okay, so why else do we care? I think that this is not going to be shocking to anyone on this call, but maybe in some of the other seminars I give is very shocking. There is just a ton of data, right? And the amount of data that there is just keeps growing and growing like a hockey stick level. So because this amount of data grows and grows and grows, the cost related with mining that data or what intelligence you can gather from that data increases as we're moving along in time. There's one statistic that is not on this slide, but I usually talk about. There's 8.2 billion text messages sent every day. And the only reason I know that is my wife sends 8.1 billion of them. So that's a little eDiscovery joke there. Sorry.
I hope she likes it, Ray.
She does. But if you look at the average case, right? So and this is grown substantially. So the average case involves approximately 130 gigabytes of data across 10 to 15 custodians. So that's on average. Francesca has to understand the interactions that 10 to 15 people have with a case, right? So what facts can be gleaned from that case? What facts can be gleaned from those witnesses that help Francesca tell her story in the most compelling way for her client? And so our job is to make sure that we defensively get those 130 gigabytes, but we don't have to we don't have to talk about every bit of metadata and every bit and byte with the litigator, because if we do that, we're distracting from the story. And so, Francesca, anything to add to that part?
Yeah, I think the other thing to keep in mind is you're often dealing with clients that don't want to be in this situation, don't want to have a lawyer tell them that a vendor has to come and essentially violate their inner workings of their systems. And a lot of times it's particularly sensitive when you're dealing with text messages and cell phones. And we are in a world now where a lot of employees, for convenience, utilize their same cell phone for personal and business. So there's a delicate balance that we have to strike to make sure that we're getting enough, but not getting too much. And so you've got a client who already is sensitive to the data, but then now we're telling them that it's going to cost, a ton of money to mine this data that they don't even want to mine. And so there really isn't time or energy for us to get into the metadata, because Proteus has to explain how I can explain to my client what exactly we're going to do and how it's not going to bankrupt them or violate their privacy. So there are a lot of other competing factors we have to deal with as litigators before we even get to the point of mining the data and getting it into a place where we can send it to opposing counsel.
Yeah, and in addition to that, in your experience, is there a separate bucket for eDiscovery costs and merits litigation costs? Or is it one pool of money that has to be divided up between these two areas?
It's one pool of money, and it sometimes feels a little jarring to present the eDiscovery costs, because I think for so long, clients thought about, okay, well, I'm hiring this attorney, this is the billable hour rate, and then there may be some fees and costs. And now we're in a world where those fees and costs are exploding because the capabilities are just so vast. So what you can gather has just ballooned, and you can't tell the client it's fine, no one will ever know, because now judges have become accustomed to what exists out there and what eDiscovery vendors are capable of culling and mining. So there's an expectation now that a large corporation that you're defending is going to be able to get the resources to get all of the documents to opposing counsel. And you're not going to have a lot of patience from a judge by saying, well, this is expensive, Your Honor, or this is going to disrupt my operations, or, this is going to take a lot of time. Not a lot of sympathy from judges, depending on who your client is.
Yeah, and in your experience, have you seen there's this concept of proportionality that we're all familiar with now? What if you compare the proportionality principles to this explosion of data? Do you see the costs going down, staying the same, or going up?
I mean, the costs are going up. I mean, it's just so interesting, because I think it's a mixed bag, right? Because we used to deal with tar technology. Now we're dealing with AI. But just because AI exists doesn't mean that everything is more affordable now, because there is a huge learning curve, and there's just more data that can be collected. And it looks like we have a question.
Yeah, so do you see data mining today to be more pointed or specific versus the old days of simply imaging an entire device as a matter of course? So I'll talk first about it.
Yeah, please.
Absolutely. The tools are getting so much better at being able to target collections that we've seen a shift from, all right, we're just going to collect this whole mailbox and filter everything on our server after processing and after getting it in, to, all right, these are the date ranges we're interested in. These are the 5 custodians we're interested in. Let's run a search on, I mean, a great example is Purview, like Microsoft Purview. We can go in and run some light searching on there and then export out a smaller set, still defensible, still has clean margins around it, but is not the, you know, petabytes of data that have to get processed, much to my own chagrin because I can't host it forever. But much better for client cost, being able to do some of those services before the data gets exfiltrated and put into a different system.
I think we have a great question.
Yeah.
You know, how do we sell the idea of an electronic review when clients seemingly don't want to pay for data storage and processing, et cetera? That's such a great question because they're not knowledgeable in why you need it and the sort of the benefits of the various different ways to store it. So I think you have to think about when you are starting matter as a litigator, and is it going to be a situation where this client will likely be sued over and over again for these same issues? If that's the case, you need to think about it fundamentally different than a case where it really seems like it's a one-off. Because you may want to front load and do a lot of data mining up front to get it all out of the system so it's more convenient for the client and will ultimately be less expensive long-term because the vendor doesn't have to keep going back and forth, but that's a big upfront cost. And then you're dealing with long-term storage. And so I think to answer your question, you know, how do we sell it? I think it's a combination of explaining what the court is going to expect and the accompanying sanctions that may come with it if the client does not take these steps. And those sanctions may be harmful both financially and reputationally. And then also the cost savings that will come from doing an upfront data collection and storing it at a more long-term affordable rate. If you can make a representation or a prediction to the client that, look, this is not going to be your last lawsuit from a plaintiff who's saying that your product killed their cousin or caused some severe, terminal disease in their body. So I think it's about understanding the details of that particular case and understanding what's going to happen long term.
Yep, absolutely. And so we'll move to the next slide. I see another question there, but I think that's going to get more handled as we continue on. So we'll address that in a bit. All right, so looking at the priorities for litigators and the priorities for eDiscovery practitioners, you can see there are certain things that are lightly bolded that we both agree on. That's preserving privilege and producing clean work product, hitting deadlines and staying within budget, and protecting client relationships and firm reputation. Those are definitely things that at the core is what the end goal that we're all going towards. So, I'll speak on the eDiscovery practitioners' priorities. We want to be able to create repeatable processes for consistency. We want to ensure data integrity. We want to find the source of truth. So we know that data can be stored in multiple places. We want to find that source that has the most complete data with the best set of metadata. And we want to be able to collect data for a wide number of uses. So there may be one text message that's the smoking gun text message, but we know that down the line, we're going to get asked to collect that whole phone or collect, this other set of things. And so we want to be able to collect the data so it can be used multiple times. And so we don't have to go back and recollect and have different scopes of collection, because it becomes a nightmare to take care of. So Francesca, what are some of the litigator priorities with regard to eDiscovery?
I think what you have outlined is a great foundation for all the things that we need as litigators. We need to make sure you find the source of truth, because then that'll help us find the most impactful documents. And then we need to work together to find search terms and ways to review that allow us to get to those key documents in a short amount of time. And I think this relates to a question we have about, the additional issue of making sure that internal legal holds are properly implemented and not forgotten at the risk of having a spoliation claim, because that is a big issue and that, both Ray and I have seen firsthand. And as a litigator, that's one of the first things you need to do. You need to make sure that you tell your client, do you ask your client, what legal holds do you have in place? And if they don't have any, you get them in place, because that is something you don't want to find out 6 months down the line. And you kind of just work backwards from there. You have to take the client at where they are. You can't create data that doesn't exist. And, I think, it's a balance. Having a very extensive data collection leaves you open to finding a lot of unsavory documents, but at the same time, we do have an obligation to the court.
Yeah, absolutely. And then to answer the next question, we do have sources for the slides. I'll make sure to have Amy send those out, so everybody will get them. All right, so the next slide is something that we need to keep in mind as eDiscovery practitioners, and that's keeping the main thing, right? So these cases get filed and they get litigated, not to figure out, what happened to the one email that was deleted in 1997, but it's about a breach of contract or someone that's hurt or an accident. And we got to keep the main thing, right? And so what's going to distract from that is talking about overly technical jargon. That's a very quick way to lose a litigator, is to talk about overly technical jargon that has nothing to do with what we're looking for. It's critical for us to understand that as eDiscovery practitioners, but intimate knowledge of these things isn't important for a litigator. Understanding the why behind is important, and being able to distill that down into a way that anyone can understand is important. But the overly technical things, not going to get there. And in fact, getting too far into the weeds at the wrong time, it does create friction in the relationship. The next thing is not keeping track of how we got here, right? So it's our job to make sure that we keep track of the choices that were made. And this can be anything from the legal hold process, keeping track of who got it and when they got it, and when they signed off on it, and when it was followed up on, to understanding those specific colloquialisms within a company. So a 20-year employee may refer to something as the G drive. And a 5-year employee may refer to it as INFS04. And a 2-year employee may refer to it as the H drive because it got turned into the H drive at some point. And being able to create those data dictionaries to understand that people are talking about the same folder, that's our job as practitioners. And that's a great way to add value for the litigators who will be like, well, this person said G drive and this person said H drive. Why didn't we collect both? And then to understand that, well, it's actually the same thing. The next thing is not understanding where you're going. And this happens a lot with some counsel, is that merits counsel has a very specific path of where they're going and how they're getting there. There's the motion to dismiss, there's summary judgment, there's deposition, and then there's trial, right? And they need certain facts in certain ways, and understanding that helps us as practitioners know what to collect, what to preserve and collect, what to process, when to process it, and what steps are going into the review and the production. This is not a one-size-fits-all thing. Every case is different. In some cases, you may need to produce everything and boil the ocean, if you will, on collections. And in other cases, that may just not be important. So understanding where you're going will help. And then lastly, preserving the budget for the merits. eDiscovery, for better or worse, and it pains me to say this, can be a huge distraction. And that's the last thing that we want. There's one pool of money to both defend the case and to settle the case. And eDiscovery takes away from both of those sets. So what we need to do is find a way to obviously do all of the things we need to do, but also understand that eDiscovery is a means to an end, right? And that ideally we want it to occur in the background. When there's motion practice about what was collected and what wasn't collected, that the tail can wag the dog in that regard. And that's not what we want. We want to make sure that we're talking about the merits of the case and put that in the best light possible. Francesca, anything to add on that one?
I agree. I think when we get to a point where we're fighting about eDiscovery, it means that something was probably missed, that opposing counsel became aware of. And so then it becomes this entire sidetrack where, now we have to get into documents being produced that likely have no bearing on the merits of the case. And I should clarify, it's not always documents being missed, but rather sometimes you have sophisticated opposing counsel that get documents in unsavory ways. So they may have worked with other defense attorneys in the same bar, and they gather documents, and then they go to the court and they say, look, Your Honor, we found this document on the street, and this shows that they've been hiding documents from us. And so we go through this entire circular argument that literally does not move us to the end goal of figuring out a resolution on the merits of the case. And to answer the most recent question we got here, I think we can strike a balance. And the question is, I've seen litigators not understanding the relationship between a hash and a deduplication. That's critical. More of a comment, but yes, that's true. That things like that are important. And I think working with your the vendor and the litigators working together to find a balance, even with terminology, because deduplication is important. It's going to save money. It's going to save time. And you just need to put it in language that helps the litigator understand why it's important, and maybe say, you don't want duplicate documents. So we have to do this. And dumb it down for us sometimes, and then we'll get on board.
Absolutely. And great next question as well. We're actually going to address that in an upcoming slide. So we're going to hold on that one for a moment. All right. So highlighted steps in the process. So here, this is where we're talking about the legal hold question. So this is where eDiscovery practitioners can add value in the legal hold process. And then Francesca, I'm gonna grill you on this. Actually, maybe not, but we'll talk about it. So we can provide comments on potential sources based on our knowledge of the company. So it's our job when we first get brought in to understand the map of where the data resides. And this obviously can be, if it's a small company, it can be a little less daunting. If it's a large company that's been around for a long time, it can become very daunting, because most of the cases that we deal with aren't something that happened yesterday. There's something that happened 2 years ago or 5 years ago, or you need to collect data from even 100 years ago in some cases. And so understanding the progression of where that data resided at different times is going to be key for us putting together a hold that is defensible. Now, the initial hold that gets put together, and I've seen this, I'm sure you've seen this as well, that's not the be-all, end-all, right? That's the beginning of the process, is you have that conversation of, all right, who in the company has data that's relevant? And you get that hold out immediately, you talk to IT, have them freeze the document disposition process on that data. And then you start talking to people. And as you talk to people, you're like, well, actually, John knew something about this. Or actually, it wasn't really me. It was Susie that dealt with this specific aspect. And so that hold needs to evolve, both from a number of people being held and from the data sources as well. You learn about a server that went offline in 2022, but the data from that server wasn't migrated to the cloud because they thought they'd never need it again. So this is where the practitioner, the eDiscovery practitioner, can really help the litigator have a fulsome understanding, or at least do everything we can to help minimize missing data sources or potential avenues for more facts. So providing a platform for distribution and compliance with the hold process, that's something that an eDiscovery practitioner can do. So in larger companies, there's internal resources that can really do that, but that's where we need to understand who does what inside the organization. And if there's not someone there that does that process, that's a great function for an eDiscovery practitioner to take over, because it helps us dot the I's and cross the T's and helps ferret out maybe some issues. And then confirming and following up on the hold. That's another great place where we can do things. Francesca, what else? Where else can we help you?
I think the conversations are really key, because you're going to find out that somebody kept a box of files in their home, and understanding how we can work with the eDiscovery vendor to take physical documents and get them into the system. That's like a fun additional layer that we need to understand and we need to go after. When you think ESI, you might have litigators just thinking, okay, things on the computers, but they don't realize that it really encompasses sometimes getting those documents into the computers and what that entails.
Yeah. And then a great question here about what do we think the best way is to create efficiencies between the litigation hold process and the Rule 26 initial disclosures. So I guess the first thing that I would add to that is, from our perspective, it depends on when we get involved, right? So if we're involved right at the beginning of a case, which ideally we do get involved at that point in time, having those putting the eDiscovery practitioner on having conversations with the IT department is a really quick and easy way to understand the scope of the data sources. Those intricacies that Francesca was talking about the pile of documents at someone's desk at home, or the box of documents we donated to a library 6 years ago, those sorts of things come up in the custodian interview process, which may lead to an amendment of a Rule 26 initial disclosure. But that set of initial disclosures, like if we have merits counsel talk to in-house counsel, or talk to the couple of key players to understand who's involved, and then we have the eDiscovery practitioner talk to IT about what data sources are involved, that's a quick way to cut through some of this and gain some efficiencies. So send out the legal hold letter, but also have those data sources identified through the process. Francesca, anything to add to that?
Yeah, and at the end of the day, we're just doing our best, right? We can't represent things we don't know. We can't represent things that, just weren't discovered at the time we, for example, submitted the Rule 26 initial disclosures. So it's about making sure that eDiscovery counsel and merits counsel stay in communication when things arise. Don't be afraid to come to the litigators if you find out about something that, just nobody knew existed. at a certain point, the worst thing that anybody can do is hide, because the quicker we get ahead of things, the better we can then make those amendments. I don't think a judge, unless they're really rotten or mean, is going to hold it against you if you genuinely represented something that you knew to be true at the time when you made the representation. We're just doing the best we can. That's all I think we can ask of one another.
Yeah, reasonableness in the process, right? It's not perfection, but it's reasonable is the standard.
Right.
Great. So protocol negotiation. So there was a question a little bit earlier about actionable steps to reduce or avoid the likelihood of the motion practice. This is where the rubber meets the road on some of that. In particular, the protocol is a good way, if you know something is going to be an issue down the line because this client has had 10 cases and this one thing or two thing or three things are always an issue, or there's a certain data source that a certain data source that is has some issues with it, putting that in the protocol or having that in your disclosure is a great way to start to avoid that motion practice. Like Francesca said, early disclosure is always better than having to scramble at the end. You have a lot more options on how to handle something if you know it's an issue at the beginning. And so this is a great way to help avoid some of that motion practice. All right, so these things, we know these things as practitioners, and this is where we insert ourselves. And this is probably the place where you get the most technical and talk about the hash values and the illusion rate and what generative AI can and can't do. Because getting those things into the negotiation of the protocol is a great way to forestall some of these issues. So I recommend doing the protocol early and often. So very early in the case, and right at the 26F report time is a great way to do that. All right, so custodian interview process, just jumping through here. These are things that we've already talked about, so we don't have to go in depth here, but where we can add value is creating a form that has that repeatable process to it, but also giving areas where we can do more or less depending on what's going on. Sitting in on the custodian interviews is important for us. Because that helps us figure out the language that the client uses, so we can later get back to those sets of documents. Another thing is making sure the list of custodians, matches right through the interviews. And if it doesn't, then we decide what needs to be added or removed. And then also keeping that list for adding more people to the legal hold in the future. Those are great ways for us to sit in on the process. And for counsel, this is where that initial fact gathering occurs, understanding what went on in the case and who might have data for different periods of time, or what facts are good facts or bad facts in a case. Anything to add on this point, Francesca?
No, you covered it. Thanks, Red.
Awesome. Well, that's good. All right, here's another area where things can go awry, is the processing and review of documents. So there's this big distinction here, because us as eDiscovery practitioners, we have deep knowledge in this area, how data is processed, how it's deduplicated, how it gets to review, and what all of the different options are. There's a myriad of different options for getting through the data set. What we need to do is present tested and true options. There are very few clients that want to be on the cutting edge of a brand new way to review documents. And I think, Francesca, you'd agree with me on that. There are very few clients that want their name on the court opinion saying that something is okay or not okay to do. So in that rare circumstance is a really great time to try the brand new thing. But on the 99% of cases, bringing the tested and true option is the best way for your client and the best way to mine the data. Whatever decisions are made, making sure that we document those decisions. So when something gets challenged in the future, Merits Counsel can say, hey, Ray, what the heck did we do here? Why did we do this? Why didn't we produce this document? And being able to go back and say, well, the protocol said this, here were the decisions related to that document or that type of document, and that's how we got to this point. That arms Francesca and litigators with what they need to go into court and say, our process was reasonable, and here's why it was reasonable, here's why it was documented. It doesn't necessarily have to be right. It could be the wrong decision on a particular document, but because we have a process behind it, we can fix it. Without that process and without documenting that process, that's where things go off the rails. Another bullet point, most cases aren't the right fit for the latest and greatest tool. Most cases you just want to get through it. You don't want it to be a distraction. And then nobody cares about the fancy stuff unless it saves time and money. And don't expect someone to learn a brand new process or technique on the fly. That's something that takes a long time. The practicing law is a lot like driving a cruise ship. You know, you can't make those fast moves that a speedboat can make, but eventually you do make a turn. Something to add there, Francesca?
Yes, I mean, I think you have to find ways to explain it. If it's something that saves money, avoid the technical jargon, unless you have a litigator who is really interested in it and has time to learn it, but you're rarely going to find that. What you need to do is say, look, this is the universe. We have the capability to do X, Y, and Z to save you money, to save you time, and to, you know, have it funneled down appropriately. And then I would say, and I can trust that, Ray, you're not going to like put me in a position in front of the judge where I can't defend what you've promised or what you've done. And Ray's going to say, of course not. Of course you're not. I'm not going to put you in that position. And this is why. And then we QC it because, you know, and I think you're going to get there next, but QCing is huge because we need to know, did the process work the way it was intended to work? And that's the only way you can know that is through doing some sort of quality control.
That's absolutely right. And that falls on us in conjunction with Merits Counsel. So Merits Counsel understands what the end goal is, conveys that, and we make sure that our QC process fits that end goal. So we want to make sure that we're identifying the right sets of documents. We're looking at things that may have been marked as not responsive to make sure we got it right. And we're floating those questions up so Merits Counsel can weigh in on those. And then we can tweak the process or at least understand what decisions were made and why they were made. So that is a huge part of how the working relationship can work between eDiscovery provider and Merits Counsel. Okay, so this is where, so Motion Practice 26F conference, this is probably one of the more difficult areas for that relationship between vendor and litigator. And part of that is we, on the vendor side, want to get so in the weeds on, this metadata field was missing a comma, and this load file, had a wrong label on it. While those are all great factoids, they don't necessarily get you to the heart of what is happening in response to a motion to compel or in the context of a 26F conference. And so what we need to do is understand how to boil these difficult things down into digestible bites. And that was a eDiscovery term, bytes and bits. So you're welcome for that. But we need to be able to boil it down to a level that people that don't have degrees in IT or computer technology can understand. Another great way to help is creating visuals. At the end of the day, litigators are storytellers. And what we need to do is create things that help enhance the story. So this can be a timeline of when different aspects of the eDiscovery process occurred. This can be an infographic showing a funnel from the custodian interview process, how many documents were there, all the way down to what was produced. And this can be bringing together some shining examples of how we complied or how the other side didn't comply with what they needed to. And all of these things help tell that story to the judge. And the other part about this is there are decisions that are made all along the way here. Us helping litigators understand the risks of each of those decisions helps us navigate the 26F conference better. So if we are agreeing to produce things in a certain way, but the technologist knows that's not possible to do, or it will add 500 extra hours to do it this way as opposed to this other way, that's where we can really add a lot of value. Francesca, what would you like to add?
And we want to know that. Yeah, we want to know those details because then we can put those in opposition to a motion to compel. If you're really good at graphics and timelines, I mean, I can recall a case where I asked Ray, can you give me a visual that I can show the court to explain how we got from culling, a terabyte of data down to a production of, 1 million documents. We had a crazy journey of discovery together that went on for years and years and years. And we had to get to a point where we could articulate how much work and effort and time and money went into the process. And sometimes having a visual is very persuasive to the court. It helps the judge. It helps the other attorneys.
Yeah, and when you get the other attorney using your visual to talk, that's always a great thing as well.
You've won.
Then we're talking about it as you framed it, and that's what you want. All right, so we don't have to spend a whole lot of time on these key takeaways, but one of them is translate legal tech into legal benefits, right? So, CAL or TAR or all these other terms, that just becomes faster, safer productions, right? That's a way to translate it. You want to speak to incentives. So wins, client retention, cost control. There's great takeaways there. And then use story-based examples to illustrate value. A lot of these concepts are very obscure, and it's our job to help tell that story in a way that everyone can understand. So these can add a lot to the mix. Let's see. So here's some tactical tips here. Avoid technical jargon. Just try to avoid it. Distill those issues down. Focus on the outcome. Focus on what's the end goal and working back from it, not the features of this piece of technology or that piece of technology. Look at what the end goal is for the client and for the litigator. Work back from that in order to find the right feature set for that case. Offer strategic insights. This is key. Don't think of yourself as just a vendor. Think of yourself as a partner in getting the client to their end goal. And this is where you can offer those insights and say, well, maybe we shouldn't do it this way because of this cost or that cost, or we actually were missing this piece, this 2 years of data, and so we want to make sure that we don't focus on it. That's a great thing there. And then also build trust by anticipating the pain points in the discovery process. All right, so that gets us to the Q&A portion of things in the last 5 minutes or so. But to answer the one question that's sitting out there, yes, the protocol refers to the ESI agreement. Mary.
Well, you've been doing such a wonderful job of answering questions as they've come in, but we still do have some outstanding.
Okay.
The first one is sometimes unsophisticated clients will send emails as attachments to emails to the attorneys for review and processing. And how do you handle that communication?
Yeah, that's really good. So it depends on a couple of factors. One is how big is the case. If it's a small case, redacting the top part and producing the bottom part, as long as people understand that you're not going to be producing it in a relativity format or things like that, that could be just fine. We don't have to every single case put it into a review platform and pull out every piece of metadata. Some cases just don't warrant that. So that's one thing. Second, you might have to have that conversation. I'll let Francesca talk about that conversation, but you might have to have the recollection conversation.
Right. I think it comes down to size. So if it's something like Ray mentioned, where it's a one-off, we're talking about 100 documents total, we may not really engage a full suite of services from an eDiscovery vendor. And sometimes it's helpful to have an eDiscovery vendor explain to the litigator, okay, here's what I would suggest. You can actually do this on your own, or we can help you do this, and then you can produce it this way. But if you find that this is a chronic issue, which can come with problems because we want to make sure we're producing parent documents, and attachments is like children documents, what I call it. I don't know if that's still the current lingo. But you need to make sure you're doing it in a way where things don't get lost and things don't get separated, so that there's not a misunderstanding about why that attachment was sent. And God forbid if those attachments were a part of a privileged communication. And so, we want to make sure that we have conversations with our client to also say, please stop sending it in this way, because now there's going to be a duplication of documents in your email that we're going to call, and then that's more expensive to deduplicate and deal with the privilege issues there. So I think attorneys have to be upfront with their ESI vendors as well to say, here's what we're seeing, so that the eDiscovery folks don't miss out on a whole pool of information. I think the biggest thing is just communication between the two. Here's what I'm seeing, and eDiscovery vendors saying, here's what we can offer, here's how we can fix this problem.
Excellent, thank you. And we have another one. We had an ESI stipulation acknowledged by both sides, but once the other side would say things weren't produced when they actually were because they lacked knowledge on how to handle databases. How would you handle that situation?
Boy, it sounds like a case Francesca and I had. So there's a certain amount of, there's just going to be that back and forth that occurs. And if you can show a couple of examples of, well, actually, no, here's the document, here's how you get to it, document that in a letter instead of just a phone call. Because inevitably, if someone's having those sorts of questions, there's going to be emotion at some point. And you want to be able to one, generate leverage, but two, also have that credibility going in that we've answered these questions that they came up. There's not been an issue with this. We went through this process to get there. And so documenting all of that, it doesn't necessarily cut it out from happening, but it certainly nips it when the motion practice does happen.
And I think it's important to remember, even if you end up having a conversation with that person, have a lead up to that conversation with an email that explains that you're going to have a conversation, to walk them through how to access it, offer to do it, and say, I would be so happy to head over to your offices to show you how to access this, or do it over Zoom. And then follow up after the meeting. I'm so glad we could have that meeting where I showed you exactly where that document that you claimed you didn't have was located, because we absolutely have seen instances where it ends up being a he said, she said, and the court's like, well, I don't know what happened because there's nothing in writing.
Yep.
So don't have that happen to you.
Documentation is king. That is excellent. And we're at the top of the hour, believe it or not. This has been a wonderful, wonderful conversation. We'd like to thank our trusted partner, Proteus Discovery Group, for making Ray and Francesca available for this educational and very thought-provoking discussion. Our thanks to the EDRM community for your wonderful questions and kind attention. If you enjoyed today's presentation, show our faculty some love. Check out the resources at the bottom of your console. Find some emojis on Emoji Day, World Emoji Day. And if you really love it, don't forget to click the link to schedule a meeting with the experts at Proteus. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thank you.
Thank you.